We talked a little bit about, I'm a baseball guy. I'm a baseball guy. And you were a bat boy in the early steel partition days. Was baseball part of your growing up?
Well, I played for the first years of my life, for the first 11 years of my life. I lived in Wheeling, West Virginia. And for most of that time, I lived across the street from a big playground. And we played two games there primarily. Baseball in different versions, sometimes real baseball, sometimes baseball in which we emulated players and threw a tennis ball against a brick wall as a backstop. And the other was basketball, and there were several basketball courts. So I spent a lot of time in that playground, especially playing those two sports. And now this was a time when parents, at least my parents and the parents of my friends, were comfortable with a child during the summer who would say, thanks for breakfast, I'm going over the playground, be back for lunch, then back to the playground, back in the evening. So the games were not organized. This was before Little League, and so it was just playing. Playing without adult supervision, generally speaking, but really a source of wonderful times and wonderful memories and wonderful friendships, as a matter of fact. And it led to an interest in sports generally. In those days, I remember listening to baseball games on a little portable radio tucked under the covers when somebody thought I was sleeping. And because I was living in Wheeling, West Virginia, the broadcasts were from Pittsburgh.
KDKA, I bet.
That's right. And they included fake broadcasts in which the announcer would sit in a studio in Pittsburgh and broadcast an away game. And you've heard this or heard about it. And the game would be described by, I guess, teletype or something, and every once in a while the teletype would break down, and this has been written about in many places, but I heard it from time to time where the announcer would have the batter fouling off pitch after pitch until obviously the connection was reestablished. But the intersection of playing games, sports, and watching sports has been an important source of pleasure for me.
So who was your go-to guy as a Pirate fan in your early years?
Well, the early years, Ralph Kiner, Wally Westlake were two of the principal stars on the Pirates in those days. And then they continued, Westlake not so much, but Kiner continued until the latter part of the 1950s when the Pirates sort of came into their own for a while. And for a time, the Pirates had a shortstop named Clem Koshorik. Clem Koshorik was a little guy, and I had seen him play. Why? Because he played at least for one season, and maybe more than one, for the legendary Jamestown Falcons. Late lamented Jamestown Falcons, who drew big crowds into that beautiful stadium. And in the post-war period in late 40s and early 50s, it was really an interesting experience to see professional baseball literally up close. Four guys, some of whom would eventually get to the big leagues.
When were you born, Chuck? What's your date of birth?
1937.
So 1937. As a result, you would have been 4 years old when the war started, but do you have a corporate memory of the war itself and how it impacted your family?
I remember several moments. I remember being told that this was an important day because there was going to be big trouble. So that would be Pearl Harbor Day. So coming, in 41.
One.
So I'm 4.5 years old. I remember blackouts because Wheeling, West Virginia, where I lived at the time, was steel producing area, and there would be occasional blackouts. Happily, like most of the country except for the West Coast, not really subject to attack, but I recall that. And also, Wheeling was a big industrial center and for steel production, and also there were a number of coal mines operating in the area. And people were working in factories at several shifts a day during the war. So I remember seeing large groups of people going and coming from work several times during the course of the day on a regular basis.
Your dad worked for Swift.
My dad worked for Swift and Company, a large national meatpacking company.
Were you subject to meat rations?
Yes, but I think occasionally I got an extra hot dog, a cold hot dog when I would visit at the plant.
You had access. Because wasn't Weirton Steel, wasn't that part of Wheeling, West Virginia?
Weirton is another town. Weirton is a city, I don't know the distances, I haven't been there for a long time, but Weirton, I would guess, is 20, 25 miles north of Wheeling.
Okay.
And they're both situated in the northern panhandle of West Virginia, which sneaks up between Pennsylvania to the east and Ohio to the west. Weirton, it is said, was the source of that great movie about Vietnam, the title of which I'm forgetting.
Yeah, it was one of the first ones that came back about the bar scenes in Weirton, yeah.
Right, and bar and bowling scenes.
Yeah.
Was it not Apocalypse Now? I'm forgetting which one it was.
No, it was one of the first that talked about the Vietnam War, and it's iconic now.
Right.
It's iconic.
Right, exactly.
Wow.
Exactly.
So you were born in West Virginia, and then found your way back to Jamestown here.
Yeah, my parents were both from Jamestown. All of my grandparents were either born in or derived from Sweden, and ended up settling in Jamestown. And my parents met here and were married here. My father had graduated from high school in a small village near State College, Pennsylvania. But his family had moved to Jamestown thereafter. My mother had gone to Jamestown High School, as eventually did I, and as Robert Jackson. So they met in Jamestown. My father was working for Swift. He had been moved from place to place, and when I was born, they were living in Wheeling, West Virginia.
Then you come back here and start attending the school system here.
Right?
So what's that arc?
Well, I had finished sixth grade in Wheeling. So when we moved here, I'm starting seventh grade, and I went to Washington, then junior high school. An hour ago, I drove by the site of that school, which is now called Washington Middle School. But in those days, in the Jamestown school system, and you may know this from your own experience, grades 7, 8, and 9 were taught at Washington, Jefferson, and Lincoln junior high schools. So I went 3 years to Washington Junior High School.
And went to Jamestown High School, and did you graduate from Jamestown High School?
I did.
What class?
Class of 55.
So 1955. Was there at that time, well, let's see, the Korean War had ended. Were you subject to the draft at that point?
I was, but I was deferred because I was going to college. So in those days, when you hit 18, you signed up for the draft. And I graduated from Jamestown High School in June of the year when I turned 18 in 2 months later in August. So from then on, I was subject to the draft, exactly.
Your academic career, you mentioned it last night, but I think for the camera and your kids, they may find that of interest. As you were contemplating life after Jamestown High School in 1955, you had a conversation with the principal and a counselor, and how did that sort of alter your thought?
Well, the conversations were quite inconsistent. The principal of the high school told me that I shouldn't plan to go away to college because I couldn't really afford to. The counselor, a wonderful man named Clarence Peterson, told me to disregard that comment. And in fact, Clarence Peterson was responsible in many respects for encouraging me to apply, and in fact, arranging for some scholarship assistance to go to Allegheny College, a place that you know well, and a place where many people from Jamestown area have studied and happily experienced that wonderful college. In the end, I didn't go there, however, because an opportunity had arisen to study at the University of Buffalo. And Sam Lasser, who was a sort of manager of the accounting firm then called Seidman and Seidman, had arranged for me to meet the dean of the business school at Buffalo. And through that, it was arranged that I would have a scholarship from General Motors that covered all of my expenses, which took care of the reason for the principal's counsel. And I wanted to study economics and took enough courses in accounting so that I could have sat for the CPA exam, since I thought it'd be a really nice idea to get a job after 4 years of college. In the end, as you know, I went on to law school and never did work as an accountant.
Went to Chicago.
I went to law school at the University of Chicago, exactly.
That had then, and continues to have an incredibly high reputation. Was that, did you really know it at the time, or what was the draw to Chicago?
One of my very good friends at Buffalo, a man named David Truax, who's from this area, and with whom I'd become good friends, was a year ahead of me at Buffalo. And he said he really wanted to go to Chicago. I didn't know one law school from another, as a matter of fact. So I thought, well, I should apply there if he thought it was really good. He ended up going to Michigan, and so I applied to Chicago and a few other places, and ended up choosing Chicago, which was quite a wonderful experience. A relatively small law school with an excellent reputation and with easy access on the part of students to professors, and something that's not extant all of the time. But the law school at Chicago, when I was there, and I think it's still true, was very much a part of the university. It wasn't a standalone operation for people who wanted to become lawyers. So, for example, the university has always had a extraordinary reputation in dealing with issues of economics. And law and economics was a part of the routine elements of study at Chicago. Not that that's all you could do, but if you were interested in economic issues and economic analysis in the context of law and legal administration, there were wonderful opportunities to do so.
There were a couple of individuals whose paths crossed with Robert Jackson at either Nuremberg or the Supreme Court, who were somewhat noted at Chicago. And I don't know if your paths crossed at that time. One, Bernie Meltzer, and the other being Phil Neal. I think Phil at one point was the dean of the Chicago Law School, and Bernie taught for years economics. I don't know if it was at the college or the law school, I'm not sure, but economic law.
Meltzer was my professor of evidence, as a matter of fact. And Phil Neal, I did not have as a professor, but of course he had a great reputation. But among the sort of legendary teachers at the time at Chicago was Carl Llewellyn. Many people in my generation had read a series of lectures that he had given that were published in a book called The Bramble Bush, which was often recommended to new law students at the time, discussion of jurisprudence. And I remember the first class that I attended in law school was taught by Carl Llewellyn, who was coming to the end of his very distinguished career and who sadly died in my last year. But he taught the first class I ever taught.
Wow.
And times have changed, I'll tell you. He talked about the profession and relation to legal education. And he came to the end of the hour and he said, "And remember this," he said, "if you flunk out of this law school, it's hellishly hard to get into another one." And Professor Llewellyn had a limp and a cane, and he limped out. Now, here we are, 140 to 150, maybe 160 students in that class, and no one moved, dead silence. Llewellyn goes out the door, and after about 15 seconds, the door opens a peek, and he points his cane in the air, and he says in a stage whisper, "Hellishly hard." It made an impression. Now, that doesn't happen anymore, right?
No.
The style of teaching has changed a lot.
Yeah. Well, if you have any curiosity, Bernie Meltzer was here at one of our first events in 2001. We brought back Nuremberg prosecutors, Whitney Harris, Bernie Meltzer, Henry King. And so I have an interview with Bernie in 2001, if you find that of interest.
Right, that's interesting because in no academic exercise that I was involved, did Meltzer have a chance to talk about his experience at Nuremberg.
Not uncommon for a lot of those professionals that it sort of was a job. You went on, but as time went on, reflection, anniversaries, all of a sudden now they have to dust off their own memory bank. And Bernie did write a monograph at some point about the Nuremberg trial experience. So Chicago, and you graduate there. Did you know what you wanted to do or even where to go?
Well, I was considering, I assumed I would go into private practice, at least initially. I was not interested in clerking, judicial clerking. Of course, always a wonderful platform to begin a career. But I had gone directly through university and then law school, and I really wanted to get out and do something. I had spent time as an editor of as articles editor of the Law Journal, and spent a lot of time in the library, needless to say, in the 3 hours. I had spent the summer between my second and third year at a New York firm, and was considering an offer from that firm, and also the possibility of practicing with a firm in California. But then I saw an announcement from the Ford Foundation that they were going to send 10 new PhDs and/or law graduates to 10 different countries in Africa and Asia, 5 in Africa, 5 in Asia. And the idea was these were countries that were either newly independent or on the cusp of independence.
This would have been the early 60s.
This was the early 60s, yeah. And I had never been, the only foreign country I'd ever been to was Canada. Now, since I studied for a couple of years in Buffalo, you'll recognize that the international element of getting to Canada from Buffalo involved a drive of about 30 minutes. So I saw this notice Ford's going to send 10 people to Africa and Asia. At the time, the end of colonialism in the modern sense in Africa began in 1957 with the independence of what had been called the Gold Coast and by then was Ghana. So I thought, gee, it'd be a really interesting experience to live in Africa. On the other hand, I knew that if I applied for this program, one of the questions on the application would be to summarize your international experience, and I'm thinking, gee, going to Canada and that 30-minute drive probably isn't going to put me high on the list, but it didn't cost anything to apply for. So I applied for it, and to make a long story relatively short, I ended up spending what I call my first job in real life after law school was at a university in the northern part of Nigeria, where I initially was I was about 20% of the faculty when I arrived. It grew a bit over the 2 academic years that I was there, and I was involved in teaching law and economics and criminal law and procedure as part of the law degree program, and also was involved in judicial training because a new and relatively sophisticated body of substantive criminal law and criminal procedure had been adopted at the time of independence. And so there was an array of judges in what were called in those days native courts who were not necessarily trained in formal legal analysis and scholarship. So we had courses for those judges that the regular faculty of the university would also teach.
So these are formerly British colonies, and I assume it was sort of common law was what they were working from as at least a base point.
Well, in the southern part of Nigeria, a code had been adopted, a legislation based upon British principles primarily. But in the northern regions, which was more than half the country geographically, before independence, criminal law was basically what was characterized as native law and custom. And in the years prior to independence, a commission had been established to inquire into the appropriateness of various forms of criminal law and procedure, primarily in Islamic countries, because the northern part of Nigeria was basically Muslim. So the commission looked at Sudan, Pakistan, and Borneo in Indonesia, which I did not know then, but everyone knows now, is a very high Muslim population. And so the penal code of northern Nigeria, as it was adopted, was really a version of the Sudanese penal code, which in turn was a version of the Pakistani penal code. So these native court judges had a very, very sophisticated body of substantive criminal law and then complex criminal procedure. So we would help to prepare those judges who were already in place to deal with the evolution of criminal law and procedure.
And of course, these individuals who are seeking guidance from you, a young, wet behind the ears law graduate from University of Chicago, 24-year-old, I'm making that up, but you know, they're seeking guidance. Did you kind of feel a little bit you were up to the task here?
There were two things. Number one, an obvious, anyone with common sense would have substantial humility about participating in the situation. And that humility stimulated a lot of work because the desire to be useful and not to appear to be a fool was a powerful stimulus. But secondly, the idea that here was an opportunity to participate in almost the beginning of something.
Yeah.
Nigeria wasn't that old in terms of being a nation state. And what a luxury
Yeah.
to be able to participate in even a modest way in nation building in the best sense of the word.
For the camera, we should tell your family the story about your mother's reaction as you were contemplating Los Angeles, New York, and she had her own opinion as to how her son should, where he should land, but ultimately how you conveyed that decision.
Well, my mother was living in Jamestown. My father had passed away some years before, and she knew that I was contemplating a possibility of working in New York or California, and was concerned that I would choose California. I didn't mention anything about going to Africa because I thought the probabilities of being selected were pretty modest. And to this day, I'm not sure why. I think somebody made a mistake, but I didn't want to correct it. So I finally, when I discovered that I was being selected and would be going to Nigeria, I called her and I said, I know where I'm going. And she said, I hope it's not California. I said, no, it's Africa. And there was this long, long pause, and she said, well, I'll never see you again. I said, well, I'm planning to come back, and and I did.
Well, she threatened to also do something.
Yeah, she said, I guess I might as well jump in the Chattacorn, she says, which is a river that runs through Jamestown. And so I promised I'd be coming back.
2 years later, you do come back, and you had to decide then, too, what your next step was.
Well, I had decided, I'd worked in the New York firm called Sherman & Sterling during the summer between my second and third year. Had a great experience, great firm, doing great work for very interesting clients. And so before I left for Africa, I made an arrangement where I would be coming to Sherman & Sterling, but they gave me a leave of absence for the period that I would be in Africa. So I didn't really work for them, but it was understood, and I stayed in touch with partners at the firm and came back. So when I returned from Nigeria, I worked as a young associate at Sherman & Sterling in New York with the firm at the time had two offices. One was downtown in the Wall Street area, and one was on Park Avenue. So I spent some time in both offices during the couple of years that I worked there. After a couple of years, an opportunity arose, however, a peculiar opportunity arose for anyone who was interested in law on the one hand, and Africa and African policy on the other. And that was to work in the office of the legal advisor of the Department of State, in a context in which my client would be the Bureau of African Affairs. So I decided to come to Washington and worked at the State Department for about 3.5 years. And during that time, the chores that I had to do, the legal chores I had to do, was to provide counsel to the African Bureau with respect to issues arising between the United States and African countries, issues arising at the United Nations, for example, involving Africa and the like. So, as I say, the number of jobs in those days, at least, that combined law on the one hand, Africa on the other, is pretty modest. So I felt very lucky to have found an opportunity to work in those areas. For people who wouldn't know what lawyers at State Department do, some are obvious, participate in negotiations of treaties, interpretations of treaties, issues that arise if there's a coup and a change of government. What do you do about about continuing relationships with the new government, issues at the United Nations. For example, there had been litigation in the International Court of Justice for a number of years involving the governance by South Africa of an area that was then called Southwest Africa.
Mm-hmm.
It's an interesting story about international law, and without boring you too much, and anyone who might look at this, the background was that a trusteeship was established at the end of World War I to govern an area called Southwest Africa, which in fact is a little bit northwest of South Africa. The trustee was originally to have been the UK, but it was transferred to South Africa. And the idea of the trusteeship was that South Africa would be the trustee, if we looked at the analogy to a domestic financial arrangement,
Mm-hmm.
And that the trust was the territory then called Southwest Africa, and that the beneficiaries of the trust would be the inhabitants of Southwest Africa. Now, the trustee arrangement established under the League of Nations provided that the governance of Southwest Africa by the trustee could be challenged before the unfortunately named Permanent Court of International Justice. As you know, the misfortune did not derive from its failure to do justice, but it was part of the League of Nations,
Sure.
and it disappeared when the League of Nations disappeared. So after the UN is organized, now South Africa is still governing this territory, and other countries who were members of the United Nations said, South Africa is applying apartheid to Southwest Africa, and therefore its legal obligation to govern Southwest Africa for the interest of the inhabitants of Southwest Africa, the beneficiaries of the trust, is not being observed. And if the trustee fails to abide the terms of the trust, classic economic financial arrangement, the trustee gets booted out.
Right.
So South Africa said, no, we don't have any obligation because the trusteeship was organized under the League of Nations. It doesn't exist anymore. Well, there were a number of issues generally arising from the substitution of the United Nations for the League of Nations. And it was the argument that had been made in a number of different contexts was that the obligations continued over and that the United Nations would have responsibility for elements of the legal arrangements, including the right to challenge the conduct of the trusteeship. So South Africa said, sure, you can challenge the trusteeship at the Permanent Court of International Justice, which no longer exists. So there were a number of hurdles.
Wow.
Number one, did the obligation continue? Number two, if it did, could it be challenged now at the International Court of Justice, which was a new body established under the League of Nations umbrella? And number three, if you could challenge, who could raise the challenge? So a strategy had been developed by a group of international human rights lawyers. Think about the legacy of Nuremberg
Sure.
and Justice Jackson. And the strategy was going to be this, that two countries in Africa that had been two sub-Saharan countries in Africa that had been members of the League of Nations would sue South Africa alleging that the trust was being violated. Now, who were they? The two countries were Ethiopia and Liberia. Those were the two sub-Saharan countries who were actually members of the League of Nations. Ethiopia famously, because Haile Selassie had begged the League of Nations to come to the support of Ethiopia when Italy invaded, and the failure of the League of Nations to respond is regarded widely as an important step in the eventual failure of the League of Nations. So here's what happens. The strategy is this. Liberia and Ethiopia will sue South Africa as a trustee in the International Court of Justice. South Africa's position is it doesn't have any obligations anymore. If it does, the International Court of Justice doesn't have any jurisdiction because it was not named in the trusteeship. And number three, South Africa always took the position that, well, the separation was in the interest of native populations in South Africa because it was showed respect for those traditions. So that's how the issue was joined. And the eventual expectation in formulating the strategy was that the International Court of Justice would rule that South Africa was in violation of the trust, that then the Security Council would order South Africa to get out of Southwest Africa, and that there would be an international transition, internationally supported transition to independence, and Southwest Africa would become an independent country. So the lawsuit, by the way, another element of that was that South Africa had been taking the position that the existence of apartheid in South Africa was beyond the jurisdiction of the United Nations because, as you may know, the United Nations Charter, in an early part of the Charter, said that nothing in the Charter would authorize the organization to exercise power for matters essentially within the domestic jurisdiction of a country. Now, part of that language, I'm sort of giving a confusing discussion, but part of that language derived from concerns that the Senate of the United States, concerned with continuing racial separation in the United States, would oppose the Charter because of fear that it would invite the UN to challenge segregation as it still existed in the United States in the 1940s. Anyhow, the strategy established, the lawsuit begins in The Hague. South Africa moves to dismiss on the grounds that I mentioned, that it has no obligation, that the International Court of Justice has no jurisdiction, and they said, well, who are Ethiopia and Liberia? They don't have any standing to sue. So the motion to dismiss for lack of jurisdiction is rejected by the International Court of Justice, if I remember correctly, by a single vote. And so the motion to dismiss is denied. The International Court of Justice goes through I forget, 3-4 year period of actually taking evidence with respect to the management, the fulfillment of the trusteeship obligation, in which, by the way, South Africa continued to try to show evidence that it was really in the interest of the inhabitants of Southwest Africa that apartheid be practiced. After 4 or 5 years, word comes from The Hague that a decision has been reached by the International Court of Justice. Governments line up. Remember, the next step in this game plan was South Africa is obligated, South Africa is in violation, South Africa has to get out, or else the UN, the Security Council will authorize the use of force. So the decision comes out, and the decision was, well, Ethiopia and Liberia didn't have standing after all. Now, pretty shocking conclusion, because at least in United States jurisdictional vocabulary, standing is an element
Yeah,
of
sure.
jurisdiction, because if you don't have standing, you can't invoke the jurisdiction of the court. So quite a peculiar result. So the strategy doesn't work. South Africa says, well, look at that, we won the case. But the General Assembly establishes a special commission. The UN, the United States designated former Secretary of State to serve on that commission, and the net result over several more years was the establishment of Namibia as an independent country. That's a long story, but it gives you a sense of how the lawyers at the State Department can get involved in essentially a legal proceeding.
In your role there, or as the counsel there, did you guys write a friend of the court, a amicus at all, in support of, or did you put the United States position before the court at all?
I did not. Liberia and Ethiopia were well represented by a number of highly regarded U.S. lawyers. And the State Department was involved in providing assistance in terms of legal analysis and argumentation. I don't remember that the International Court of Justice invites amicus submissions. I just don't remember that element of the practice. One thing I will say is that we lawyers at State did not anticipate the decision by the International Court of Justice that there was no standing. So our expectation was that the strategy was going to work, and we had urged that undertakings be made in Pretoria at the time to advise the South African government that we expected the decision to be complied with. And the response was, oh, it will be. So we never knew whether information had leaked out prior to the time the decision was rendered.
Dean Rusk, was he this Secretary of State at the time?
Rusk was, but I have to say my perception was that an overwhelming majority of the focus of the Secretary and of the State Department was on Southeast Asia at the time, as you might imagine.
Yeah, exactly.
By the late 1960s.
What a thrill. What a thrill. Here's a kid from Jamestown, New York, in the eye of a lot of interesting opportunities in Africa.
Well, it was great. It was really marvelous. A life-changing experience, I think.
Was Georgetown just a logical leap for you to go from the State Department to teaching economics and law?
No, I liked law practice. When I first came to State, I thought I would stay a few years and go back to New York. But I ended up enjoying Washington. While I had lived in New York State, as you well know, Jamestown is not next door to Manhattan. And I enjoyed living in Washington. I liked to play tennis and sail and do other outdoor things that were easier, more accessible for a person of modest means in Washington than in New York at the time. So I left State and joined a Washington firm that had a lot of international work, and spent about 3.5 years with that firm, doing primarily business-related law, and an opportunity arose to come to Georgetown. So once again, I made an arrangement to take a year and teach with an understanding that there would be a leave of absence, at which time I would either go back to practice or stay at Georgetown, and Georgetown got stuck with me.
Obviously, very thrilled to do so. Before we get too far afield, you have a long-standing relationship with Stan Lundeen. Stan Lundeen, of course, long legendary career from the Jamestown area, mayor, congressman, lieutenant governor. How did your paths originally cross? Was this just a couple of young kids interested in politics?
Well, Stan, I didn't know Stan that well in high school because I was a year or two ahead of him. I forget, maybe 2 years, 1 or 2 years. But we knew one another. But we really got to be good friends because when I came back from Nigeria, Stan went to law school at NYU and was living in New York City. And we had mutual friends, and we saw each other on a social basis. Anyone who knows Stan knows that he doesn't talk about NYU nearly as much as he does about Duke. Maybe because Duke has a better basketball team, among other reasons. But so we got to be very good friends. He was in New York, I was in New York, and so we stayed in touch after that. When I would visit in Jamestown, I would see Stan, and then he became mayor, as you well know, it's widely documented, and it was rather revolutionary, I think, for a Democrat to have a sweeping victory in that election. We even chatted briefly about the possibility I might come back to Jamestown at the time in some kind of legal position, but for different reasons that didn't work out. There was an interesting coincidence about Stan's election. I think he was elected as the first Democrat in this district, in Southern Tier, for a very long time. I think he was elected in '75 in an off-year election because the prior congressman had been indicted, I think, for something, maybe taking for something, and resigned. Here's a curious coincidence. A friend of mine was a prosecutor at the time, and among his responsibilities, this had nothing to do with Stan, just total coincidence. A friend of mine who had been a roommate, one of several of us sharing an apartment in Chicago in law school, was involved in the prosecution team at the U.S. Attorney's Office in Washington. So Stan comes to Washington, and because he had to run again for the real 2-year term within the year, did not want to buy or rent a residence on a long-term basis. So he spent quite a lot of time at my place in Washington during that first year.
Really?
Well, he was back and forth.
Sure.
He couldn't afford to stop running, I assume, since he knew that the next election was right around the corner. And I think the only inauguration that I went to in Washington, even though I've lived there a long time, was 1976. And that was when Stan had been elected for a full term for the first time. And I remember after the Carter inaugural, there was a reception in Stan's office, and
oh, cool.
he was already off and running. But so since he lived in the Washington area and Jamestown, but until when 1986 maybe, when he came to Albany, we spent a lot of time together during that time.
Then subsequently, Stan was instrumental in convincing, hopefully with not a lot of pressure, but you to become a member of the board of directors of the Jackson Center.
Well, when Stan told me first, no, I first heard of the Jackson Center, I think, through Miles Lazar. Miles and I were old friends. And Miles said I should chat with you, actually, and I remember visiting you in your offices near 3rd and Main. You or some of the staff at the time or volunteers showed me around the center. I saw parts of the film of the opening statement by Justice Jackson at Nuremberg, and actually in the room where we are right now. And then Stan, over the years, we talked about the center and his involvement in the center. And I told him that I would like to have a contact with the Jamestown community, which meant so much to me in terms of my own existence. And eventually, it was arranged that I would be appointed to a seat on the board, and have enjoyed the 3 years that I've served as a member of the board.
Well, I can remember shortly after, never shy about following up me, we had an event at, I think it was at Georgetown Law, it was a Nuremberg anniversary, and you and I caught up. Met at your office with an eye towards maybe doing a mock trial or something down there at the Georgetown Law Center. But yeah, that was a follow-up connect, and delighted with all the opportunities we've had ever since then. In your role as a long-standing and well-revered professor of law, especially with the taxation angle that you have, does the jurisprudence of Jackson come up in the stream of your teaching in that area?
Well, it's, as you well know, Jackson had spent time at the Internal Revenue Service. I think he was counsel. Was that his first job when he came to Washington?
It was.
Yeah, before he took over antitrust. So he had that interest. But in terms of actual jurisprudence, not so much. I also taught in public international law, continuation of my interest from the State Department days. And there are elements of Jackson's jurisprudence with respect to international law that are frequently cited. For example, the question of whether or not it is permissible to establish a treaty obligation without going through a Senate confirmation, as required by the text of the Constitution, pops up. And in that context, Jackson's description from the Youngstown Steel case is often cited. A so-called executive agreement, of course, does not require the approval of 2/3 of the Senate. But if the executive agreement is permissible, then the United States regards it as an international obligation, a treaty-like obligation. And so the issue of whether or not the executive agreement comes within constitutional parameters often involves the question of whether or not it is a permissible exercise of executive authority. A dramatic example arose with respect to the agreement with Iran that was concluded at the time that the hostages were released. After it was on the eve of the Reagan inauguration, and an executive agreement was concluded. And eventually, the Supreme Court was required to determine whether or not the executive agreement, not approved by the Senate, came within constitutional parameters. And the Jackson analysis that is so often cited was important in that context. Why was there litigation? Who would disagree with having a treaty that resulted in the release of the hostages? Well, the answer was this, that a number of companies had sued Iran prior to the time when the agreement was negotiated. And the agreement provided an avenue for United States claimants to press for recovery against Iran in a special tribunal. And the companies that opposed the deal were companies that had already secured judgments against Iran. They had come first to cross the line, and they were concerned that the value of the judgments that they had already obtained might be impaired, at least, if they were thrown into the general batch. It's very interesting. And the whole issue may arise again. The administration now seems eager to reestablish an agreement with respect, among other things, atomic energy with Iran. And I don't think anybody anticipates that it's going to be taken to the Senate, because the Senate seems unlikely to approve by two-thirds majority. So you could see a resurrection of this issue in primarily political context.
You have been in Washington for 40 years, perhaps, if not more, and I know one of the topics you teach is the art of the Washington lawyer. That's got to be one of the more interesting subject matters, because lawyers are everywhere. They're omnipresent, practicing, non-practicing, policy-making, law-making. They're everywhere. So just the idea of the art of a Washington lawyer is really expanded.
Well, the background of this course is sort of interesting. I was counsel to another firm while still teaching, and one of the partners of that firm was a wonderful lawyer named Judy Hope. Judy Hope was a well-known lawyer involved, a litigator. She had spent time at Williams and Connolly and was a partner in the firm where I was counsel.
Bennett Williams, right? Bennett Williams?
That's right,
Yep.
that's right. That was not the firm where I met her.
Okay,
She was a partner in another firm, and she eventually left there to open a Washington office for a large California firm. In any event, we had worked together on a few projects in the firm where she was a partner and I was counsel, and enjoyed working together, and I wanted to get her involved in Georgetown matters, so we came up with this idea of a course that we called, as you said, the art of the Washington lawyer, though we also said, no paintings, no sculpture. So we didn't teach it. What we did was organize an opportunity for our students to meet with high visibility lawyers who would discuss high visibility cases. And it was some of the great Washington lawyers that you've heard of. We had an unenforceable rule in the course, which was that everything said was off the record, and so that we could undertake to our guest speakers a promise that whatever they discussed would not appear on the internet within the hour. And so we did that course, I think, 7 or 8 or 9 times, and it was always very well received. As you might imagine, students who come to Washington to study law have in mind, not every student, but many of them have in mind that this is what is attractive about Washington, is to be involved in high visibility cases. So what do I mean by that? Well, without mentioning any names, prosecutors from the Watergate case, counsel for the Senate Ethics Committee in famous savings and loan scandal, in the late 1980s that involved six senators, five or six senators, each of whom had been represented by a legendary figure in Washington legal circles. And it was a wonderful experience for me as well as the students, but especially for the students who had an opportunity to, in a relatively intimate setting, limited to 30 students, have a chance to actually hear from, ask questions of, and discuss matters of dramatic interest. And it provided often very, very moving experiences. I'll mention one. One of our guests was a wonderful person, William Coleman, a famous lawyer who I think had been Secretary of Transportation maybe during the Ford administration, but maybe I'm forgetting.
Oh, you're correct.
William Coleman, who sadly died a few years ago, had won the Presidential Medal of Freedom and is recognized in many different ways. So he met with our students for 2 hours. And at the end of the hour, this legendary lawyer, who had been a clerk, I think, for Frankfurter, if I'm remembering correctly, walked around the room and thanked our students for coming to hear him.
Wow.
Students, I mean, you can imagine, a very moving experience. So it was great fun. Not all of those academic experiences have been so successful. I remember when I was first teaching in Nigeria, after about 6 weeks, a young man came to me, one of my students, and said, "Sir, I want you to look at my notebook." And I looked at his notebook and I accurately observed, I said, "There's nothing there." "Exactly," he said, "that's what you've taught me so far." So I said something sort of pathetic like, "No, that's what you learned so far." So I thought, well, I understand that because he's used to a sort of old-fashioned way of lecturing and taking notes, whereas I'm using the United States approach of discussion and whatnot. It must have been a decade later before I was teaching at Georgetown. And by this time in U.S. law schools and universities, there were practices that were unknown when I was a student, such as the anonymous evaluation of professors by students at the end of every course. And I remember I'd finished the first semester of the first year I'm teaching at Georgetown, and I had a huge class in those days. I forget, 160 people. And I turned in my exams, and then eventually you don't see the evaluations until you've turned in the exams. The evaluations are anonymous. And I look at the first one. Now remember, I had explained to myself that my Nigerian student, it was just his problem. The first evaluation that I read at Georgetown said, "This professor should return to private practice as soon as possible." I chose to interpret the remark as a peculiar appreciation for what a fabulous lawyer I must have been. But I recognize there's another possible explanation.
Oh,
That's an absolutely true story.
well, humility is a good thing, you know. We're going to get, because I know you got a busy day today, but I can't stop without asking about another course you did. Charles H. Gustafson, Transfer Pricing, Baseball, and International Arbitration. How did that all pull together?
Well, in tax treaties, well, first of all, almost every country with a serious taxing system is concerned about transfer pricing. That is to say, the prices paid and received in transactions, usually between related companies. Mm-hmm. Because the prices can be manipulated to move income to the lowest tax jurisdiction. And therefore, almost every country with a serious taxing regime empowers its tax administrators to challenge so-called transfer prices, prices between related entities, and recalculate the results of those transactions as if they had been implemented between unrelated entities. So they'll use the term fair market value or arm's length pricing. So a problem is that while the language of the tax statute may look similar from country to country, the question of what is fair market value is not easily susceptible to congruent thinking. I mean, sometimes it is. If we're going to determine what's the value of a share of General Motors stock this afternoon, we can do it. But if we ask what is the value of a newly discovered Caravaggio painting that has been resting behind an altar place in Firenze for the last 3 centuries, a painting that hasn't been sold forever, it's tough go. So the treaties provide, so what can happen is that two taxing authorities can be looking at the same transaction. Let me give you an example. Suppose we have a U.S. company that sells to its foreign sister corporation some product for $100 per unit. And in the United States, the Internal Revenue Services say, no. You only charged $100 per unit. The value of that stuff, to use a technical term, was $125 per unit. And we're going to recalculate your taxable income by assuming that you had realized $125 per unit. And in the other country, the payment is a deduction, in effect, is a subtraction to the company, the sister company. Now, so in that country, the taxing authorities are saying, you paid $100 per unit for that? No. You should only have paid $75. We're going to recalculate the consequences of the transaction as if you had only paid $75 per unit, so when you resold it, you would make more money. So you could end up losing, the companies owned by the same shareholders could lose in both jurisdictions. Bilateral tax treaties typically provide that the two countries will use the term, this isn't the specific treaty language, but here's what it means. Will use their best efforts to bring about a consistent result that is not unfair to the taxpayers involved. Now, since about the 1980s, those treaties, the practice is called a mutual agreement procedure. And the way it works is this, to describe more tax administration than anybody cares about unless you're practicing in the area. What happens is the company goes, let's say, to the IRS and say, hey.
That is IRS, man. They're looking, probably in your bag.
I'm sorry.
No.
Can I just let it ring out?
Sure, yeah, absolutely.
Okay. I'm sure it's a sale, an attempted sale.
Well, it's an auto warranty. That's exactly what they want.
So the procedure is that the company in the U.S. may say, hey, they're trying to tax the same income as you, and that would invoke this process of mutual agreement. Now, since about the 1980s, many of these treaties, bilateral treaties, include a provision that says something like this: if the mutual agreement process does not produce a result, an acceptable result, then the two countries should consider subjecting the matter to binding arbitration. Now, many treaties have that language, but there aren't many actual arbitrations. The United States historically has not been enthusiastic about committing itself to a binding judicial or arbitral decision of international disputes. I mean, you see many examples. For example, when Nicaragua sued the United States over the Sandinistas, the United States moves to dismiss for lack of jurisdiction at the ICJ. ICJ rejects the motion. The U.S. says, we're out, we're not going to litigate this. So we're not enthusiastic, historically, with respect to judicial binding or binding arbitration. It happens, but it's not so frequent. Beginning in 2006, United States Treasury says we have a new policy, and especially with respect to disputes about transfer pricing. Think of the example that I mentioned.
Mm-hmm.
U.S. says should have been 125. Other countries says should have been 75. There's another kind of dispute resolution in place where the two sides differ about the correct number. What is that? Baseball arbitration. Normally, as you well know, in an arbitration proceeding, the arbitrator or arbitrators will take into account all evidence that's not subject to some kind of exception or protection, and will render the decision that is right based upon the evaluation of all of that evidence. But in baseball arbitration, as you well know, as the time for the procedure approaches, the two sides, the team and the players' representatives, will submit a number. And the jurisdiction of the arbitrators is restricted to selecting one number or the other. And the obvious genius of the approach is that the player's rep knows that if his number is too high, then the team's number is going to be selected, and the team knows that if the number is too low, the player's number is going to be accepted. And so inexorably, the two sides come closer
Brilliant.
together. So a number of people for years have said, look, this is what's going on with this arbitration, with transfer pricing, that in the long run, countries that have friendly relations do not need to have their agenda of relations punctuated with unresolved issues of transfer pricing. That in the long run, there's no reason to believe that one side or the other is going to be more successful. So in 2006, in a new treaty with Belgium and in amendments with treaties with, I think it was Germany, France, and Canada, provision was adopted by the two countries, which provides that if the mutual agreement process fails, then the matter will be submitted for binding arbitration. And the form of the arbitration, they don't say baseball arbitration, because most other countries don't know what baseball is, except for Mexico and the Dominican Republic and Japan and Nicaragua, maybe. But the jurisdiction of the arbitrators is restricted to selecting one of the two submissions. So
Beautiful. I know that only because my daughter Amy was Associate General Counsel for the Detroit Tigers for many years, and she was preparing the briefs that ultimately were submitted to the arbitrators and the Tigers, and it leads, of course, to conversation, because each party gets it swapped.
Sure.
And then the Tigers never went to completed the arbitration. They had to submit the paperwork. She was the one submitting it, and then they, of course, ultimately.
Sure. Well, it's a brilliant way
Yeah.
to avoid having to finally have a formal procedure.
That's fascinating.
And it's in both sides' interests that obviously the teams hate to have to go into the procedure and talk about what a terrible person their player is, because they're going to live with the player, right? So as a way of diminishing the differences between the two sides, it's brilliant. And in a sense, it take relations between the United States and the countries that I mentioned. There are enough problems in life without adding to them unresolved differences about transfer pricing.
That's fabulous. Thank you. We're going to draw closure here, Chuck, but here you are in the Carl Kappa Theater, the Robert Jackson Center. You're from Jamestown. You're a successful lawyer, as was Robert Jackson, who ultimately ended up with his career in Washington like yours. Do you get a sense of Justice Jackson in the, not only in your world, but kind of just reputation-wise?
Well, let me give you an example of his reputation among many lawyers. You can't talk about all lawyers, but I participated in a book group, informal book group, for more than 35 years. And one of the members of the book group has served in an earlier administration as Assistant Attorney General for what was called for Natural Resources, and then had a very important position at NOAA in the Obama administration. And I was mentioning that something about the Jackson Center. I think we had a program that I was telling the group about, and she said, well, she only has two photographs when she was at Justice of prior Supreme Court justices, and Jackson was one of them. And among the members of that little book group are some non-lawyers as well, one of whom gave me a copy of the biography of Jackson that was written in the late 1950s that you and I have discussed about. The author I think has spoken here on a number of occasions. But Jackson, because of, I'd say for three reasons, Jackson stands out. And I'm not telling you anything you don't already know. One is, of course, the cornerstone position on modern international human rights law established by the process at Nuremberg. Number two was Jackson's independence as a Supreme Court justice in cases that have been discussed here at the Jackson Center. And number three was his extraordinary ability to write and to speak. Now, you might say all justices got to be pretty good at talking and writing, but they're not. But when you think of the scores of excellent lawyers and some non-lawyers who have served in the Supreme Court over the years, the number of times that a formulation by Justice Jackson is referred to is enormous. For example, when the current Attorney General, Merrick Garland, was testifying in connection with Senate approval of his appointment, he referred to Jackson, something that Jackson said, but also a Democratic member of the Judiciary Committee referred to something Jackson said, and a Republican member referred to something Jackson had written or said. And I did not watch all of the hearings. I watched the hearings coming and going while I was doing other things. And so here were three references to a formulation by Jackson that was embraced and revered by different people, different degrees of the political spectrum.
And we're thrilled that you are part of us at the Jackson Center as a board member and a supporter and just an encourager, a facilitator, so thank you.
Well, thank you, and I enjoy being here. I enjoy the connections that I have with people associated with the center on the board and working for the center, volunteering with the center. And it's an important element of the life for this part of the country and for all of the country as well. So to the extent we can continue the success that the center has achieved in its 20 years of existence, we have a good example of how to enlarge the scope of the center's activities.
Thank you. This has been great, Chuck. Thank you.
Thank you.
Yeah. We good, Ed? Terrific.
Did the camera break?
No?
That was fun. That was fun. You're fun. It was fun. So many, I love that transfer pricing thing. I didn't know where that was going, but it turns out my daughter was in the middle of it.
It was probably too long an explanation.
No, well,
But
it's a beautiful thing.
well, the one thing that I always hate if I'm in the audience, is somebody talking about something as though everybody knows it, and so you're just lost. So sometimes I think I err on the side of trying to establish a context, but it's the only way that's interesting to me, so I figure.
Well, as I was listening to you talk about it, I said, oh, I hope this is what he's talking about. Where ultimately, it's a crapshoot for the teams. I mean, and sometimes the players win, sometimes they lose, but ultimately they do negotiate a settlement.
Right.
Because nobody wants that precedent.
Right, exactly.
And the Tigers, for as long as they've done that, it's been available, they've never had an arbitrator rule. That's their reputation.
Yeah. I've read data, I think fewer than 10% of the
Yeah.
cases
Yeah.
actually go to arbitrators, maybe even less than that. I have a friend who is an arbitrator, a baseball and hockey arbitrator, sometimes, but he's more hockey than baseball.
Yeah.
But was a colleague at Georgetown for years. He is, and we're both retired at the same time. You mentioned the Tigers, and I was remembering Clem Koshorek. Every year, maybe this was before your time, the Detroit Tigers played an exhibition game in Jamestown. And there were two great stars for the Tigers in those days, one with Hal Newhouser.
Okay, you want to get this here, Ed? Oh, good. This is going to be good. Go ahead.
And the other was George Kell.
Yep.
But they never came because it was usually during the All-Star break. A guy named Dizzy Trout came, and at the old Jamestown Stadium, you know, the billboards had classic ads, and one of them, I forget if it was a taxi company or something, was upside down, which is a brilliant way, because everybody noticed that an old Dizzy Trout goes out to left field, stands on his head. It was just fabulous. So it was fun for me. I'd never been to a major league game to see, even though we didn't have Kell and Newhouser, and maybe somebody agreed. Oh, Hank Greenberg too. Yeah, he never came. But it was pretty
but the
good.
who's
Koshorek
who-
didn't make it to the Tigers. He played for the Pirates.
Well, two quick things. One, in 1946 is when that exhibition game occurred with the Tigers. It was 1945. I've written a history of the Jamestown, so I'm tuned
Was
in.
there only 1 year? Was 46 the only? I thought it happened every year. No?
And so, think about it. We're Class D. Class D.
Oh, I know.
And in 1945, the world champions were the Detroit Tigers.
Right, of course. They
So
beat the Cubs.
46, the first year after the war, a guy named John Yackham, who was from South Dayton, came back. He was a purple-hearted guy who
Didn't he
came
end up
back.
owning the Senators?
Pardon?
Didn't he end up owning the Senators or
Yes.
something?
Good memory, for a short period of time with Clark Griffith. And so John, young kid, basically bought the team, had so much chutzpah that he convinced for opening day here, Class D, to bring in the commissioner of baseball, Happy Chandler.
No kidding.
You gotta be kidding me. You know, like, to me, I could be a P.T. Barnum, but that's beyond the pale. That same year, John Yackham convinces the world champion 1945 Detroit Tigers, minus their All-Stars, it was just Greenberg, Newhouser, and Kell, to come here. So everybody else was here playing a Class D team.
So they only came once?
Yeah.
I must have been lucked out. I used to come up in the summers to spend time with my grandparents, aunts and uncles.
Yeah.
And the summer of '46 was the year my sister was born. My one sister's 9 years younger than I am. And so I spent a long time that summer. My uncles were home from the Air Force and the Navy. And in those days, the Falcons were such that they'd at 11 o'clock, they'd wait for the 11 o'clock news to ask, how did the Falcons do with Hornell or Wellsville
Exactly,
or Hamilton in
It was
those
huge,
days?
huge.
It was a big deal. But I thought it was every year, so I just lucked out and happened to be
You
there the
hit-
year that they came.
The world champion Detroit Tigers. And it turned out Russ Dietrich, who you may know, Jamestown's Mr. Baseball, and it turned out that his story was that his dad was driving him home from that '46 game, and he had somebody knock on the window, and here was Dizzy Trout, who had finished the game, and was looking for a ride to come back uptown.
No kidding.
Because they were staying at the Hotel Jamestown.
Ha!
So here's a kid, eyes popping out of his head. Here's Paul Dizzy Trout. Of course, who did what he did, everybody, that was a picture, and that was a major kind
Right.
of,
He was a very good pitcher, by the way.
Very good, oh.
He sort of, I think, not too many people remember Dizzy Trout because Newhouser was such an overwhelming
yeah.
figure for the Tigers in those days. I thought it happened every year.
No, you hit bingo.
Here's one of the problems as I get older. I forget things that have happened, and I remember perfectly things that never happened.
That sounds perfect.